In a voice breaking with emotion, Linus told the jury his wife died shortly after 3 nurses entered her room with a syringe. He said, "I noticed her eyes were half open. I waited for the next breath to come, but it never came." In cross-examination, Linus denied that he had asked Mrs. Capute, a licensed practical nurse, to give his wife some relief from the pain, or that his wife was screaming in agony shortly before her death. Anne Capute sat quietly through the proceedings, occasionally taking notes. Yesterday, in opening remarks, the prosecution claimed Nurse Capute took it upon herself to administer 240 milligrams of morphine to Norma Linus during the 7-hour period before she died. Capute's defense is that she was only following doctor's orders. Before court adjourned today, Linus's doctor, Robert Hillier, was called to testify. He gave the medical background of Mrs. Linus, who was suffering from a cancerous tumor of her spine, a condition which Dr. Hillier admitted was extremely painful. The prosecution maintains that while painful, the condition would not have been fatal.
We had performed the myelogram.
Dr. Hillier's testimony is important because the prosecution says that defendant Anne Capute changed Dr. Hillier's orders for morphine injections. She's accused of injecting Norma Linus, a cancer patient, with a fatal dose of morphine in May of 1980. But Hillier is also an important witness for the defense. They maintain that Capute was only following doctor's orders to make the patient comfortable because she would die in 48 hours. Hillier testified today that the morphine injection order he verbally gave Anne Capute and another nurse who was being tried separately was not documented the way he requested, and in fact stated no time limit for the injections, but just to make the patient comfortable.
What you're saying, make her comfortable, doctor, is that correct?
Yeah.
Did you give that order?
I did not.
You ever given an order like that?
I have not.
Does that mean something in medical terms?
Not that I know of.
Dr. Hillier also testified that the last conversation he had with Nurse Capute 48 hours before his patient died was only a discussion about filling the morphine order.
Did Nurse Capute say anything to you?
She did, yes.
What did she say, if you can recall?
She says, don't worry, we'll take good care of Mrs. Linus.
But in cross-examination, defense attorney Pasquale Piscitelli attacked the doctor's credibility, attacked his treatment of the patient, wondering why he hadn't worked harder at finding the primary cause of Mrs. Linus's cancer, and questioned why Dr. Hillier ordered psychiatric counseling for Mrs. Linus a week before she died.
Did you send her to you so that he could get her psychologically oriented to the prospect of dying very soon?
I did not.
You did not.
She asked me if I knew that Mrs. Linus had died, and I said yes, I had learned that the night before. And she said she had taken care of her over the weekend. And she said that she had promised her husband that she wouldn't suffer and that she had helped her. And if you had 120 milligrams of morphine, you'd die too. I spoke with Mrs. Costello.
Who is Mrs. Costello? Were you ever contacted again?
Lieutenant Clarkson.
Do you know who Lieutenant Clarkson is?
Yeah.
What did you observe, if anything, in narcotic club? And where was the conversation held?
Mrs. Costello.
And that is a normal accepted procedure in the hospital when you do check out narcotics, to in fact do just what she did use of morphine and also gave afternoon.
You assisted in an operation, is that correct? Norma C.
Expect in a normal appearing bone.
As to who should write it? Who should write it?
I was a graduate nurse at that time.
Patient not breathing, husband with patient, supervisor notified.
What time is it?
12:30.
Doctor, what does nail beds bluish mean?
Testified.
In cross-examination, Maureen Costello was unshakable. The director of nurses at Morton Hospital has been on the stand since Tuesday, testifying mostly about practices and policies at the Taunton Hospital and her own investigation into the death of cancer patient Norma Linus. Today, defense attorney Pat Piscitelli picked his way gingerly through the trial record, trying for an opening to grand jury testimony.
Did Dr. Hillier, in fact, relate to at that time that he had told Mr. Linus that Mrs. Linus had only a week to live?
Objection, Your Honor.
The objection is sustained.
Objection, please, Your Honor.
Mrs. Costello has proven herself an exacting state witness, choosing each of her words of testimony very carefully. And it is precisely because of that deliberateness that her stay in the witness stand has been a long one. She will be back there again tomorrow morning. Jan Harrison, News 7 at the Bristol County Courthouse. Rhode Island medical examiner William Sterner studied autopsy results, medical records, as well as nurses' notes, which logged nurse Anne Capute as administering 195 milligrams of morphine within 8 hours. Based on all he read, Dr. Sterner voiced a strong opinion.
My opinion is that she died from morphine poisoning or intoxication. The cancer passed nowhere else. In other words, it did not involve the vital organs such as the heart, the lung, the liver, the kidneys, and importantly, the brain, which would be the vital organs that cancer would have to involve if it were responsible for death, in my opinion.
In the afternoon session, it was a battle of egos, a persistent defense attorney trying to break down the self-assured expertise of the witness.
It's not a yes or no.
Yes or no?
No, because I wasn't asked to.
The defense scored points in one area, focusing on the autopsy records near the neck, which indicated cancer in that portion of the spine.
We don't know, doctor, based upon that autopsy, how high up on the spine that tumor might have gone on the posterior side of the spine. I'm looking for a yes or no answer.
You got a yes, Counselor. We do not know.
We don't know. And doctor, assuming that the tumor had gone up into the cervical area on the posterior side of the backside,
yes,
that could have caused a depression of respiration and resulted in death, could it not?
Yes, sir, it could.
How? Thank you.
What portion of...
I relied on the available literature. You mean to make this a case to it because it indicates that a toxic
After we've just gone through this long dissertation on what my background is, I'm afraid I must say that I cannot tell you what killed this lady.
Dr. Watkins described Norma Linus as a very sick lady and interpreted all the medical reports as showing cancer in 7 places in her body. Other doctors have identified 4 and 5 cancerous areas. Watkins further testified that 195 milligrams of morphine, the amount given Linus by Capute in her last 8 hours of life, that 195 milligrams was not extraordinary.
I think that that's not unreasonable. I think that that's compatible with reasonable medical practice if one adapts the concept that one employs the dose of drug that is necessary to alleviate pain.
Doctor, you're still under oath.
Good morning, Doctor.
He was employed at the Waltham Hospital as a pathologist and also,
So do you know whether or not Dr. Katzis and Dr. Keeley from 1975 until May of 1981 when Dr. Katzis died were the only 2 state pathologists?
My objection, please.
Do you know that?
Yes, at the conclusion of the resting by the defense been indicated, the Commonwealth has another witness to put on in what is called rebuttal. And that is permissible under our procedures. You'll return on Monday morning, and this case certainly will be too. At the conclusion of the resting by the defense been indicated.
Good. We're going to see these pupils are too busy.
This is where the story began, Morton Hospital in Taunton. And tonight, more than 16 months after the events leading up to the Capute trial, We talked to some of the people who might be most strongly affected by that trial. Relatives of the patients here.
My mother's been here almost 4 months.
Do you have any misgivings at all because of the Capute trial?
Not at all. No, I have strong feelings about the trial, yes.
And they are?
I hope she's found innocent. I really do.
I don't think there was anything wrong that nurse did. I think this is a good hospital because I'm up here visiting my best friend who was in a car accident, but I used to work here for my school program. We used to do work for free, and the nurses are really careful with what they do.
I have been here for 4 weeks as a patient, and I was treated very, very kindly and very well.
Hospital administrators and staff has declined to talk on camera tonight, but privately, several employees admitted that morale is somewhat affected by the Capute trial. So the staff of Morton hopes the glare of publicity will disappear with the awaited jury verdict. Gary Armstrong, News 7, Taunton.
I'm still on a high with it.
Not guilty.
I'm thrilled, just thrilled out of my mind with it.
But while 2 other nurses are under investigation in the Norma Linas death, the 44-year-old licensed practical nurse said Bristol County Prosecutor Ronald Pina was trying to make an example of her.
It's probably, and this is pure speculation, it's probably a lot harder to go after the doctor who's making, what, I don't know, $100,000, $150,000 a year?
Anne Capute's lawyer, Pat Piscitelli, said the outcome of the trial should make doctors more accountable, referring to verbal orders for morphine doses the defense said Dr. Robert Hillier made. As for the Linas family, Capute said she can't imagine the suffering they went through.
I hope they can pull their lives together, really. I truly do. This has got to have been such a horrendous experience for them as well as for myself.
Capute also expressed her general feelings on terminally ill patients.
I think in this day and age with the drugs that are available to us and the treatments there, no one should die in agony.
Some jurors said they had no trouble reaching a not guilty verdict because of conflicting testimony on the cause of Norma Linas' death, morphine or cancer.
And I had toyed with the idea of putting no defense on whatsoever and simply laughing away their case because I thought it was laughable in many respects. I couldn't conceive of any fair-minded juror convicting on the evidence which was produced by the Commonwealth. For Anne Capute to have chronicled everything quite clearly in black and white, if you're going to kill somebody intentionally, you've got to be a nut to do, in fact, what was done in this case.
Today, Anne Capute says she's glad the jury made its decision based on the evidence her lawyer presented, rather than any sort of emotional pleas, including the final appeal she made in the courtroom. And she said when she addressed the jury, asking for her freedom, she was asking for her life. Ron Sanders, News 7, Brockton. The tension of the 6-week trial reached a crescendo moments before the verdict was read.
How do you find the defendant, guilty or not guilty?
Not guilty.
Nurse Anne Capute, who'd been charged with administering a lethal dose of morphine to cancer patient Norma Linas, expressed her emotions of relief and gratitude by embracing jurors who she said had given her her life. Tonight, less than a mile from the courthouse, at a restaurant called the Gangplank, there was a reunion that was somewhat difficult for an outsider to fully understand. It was out of support for Anne Capute and a closeness of her peers that this came about, said juror Leslie Tatro, who helped arrange the gathering.
My feeling personally is, yes, I think she was used as a scapegoat, but I don't think this is entering into this at all tonight. We just want to have a good time and have her and Pat included into it.
This is really a unique, very unique relationship, I guess you have to call it.
I think they want to make, they want to extend that joy that existed in the courtroom when the verdict came back of not guilty.
3 jury members, including the foreman, weren't here, but a half-dozen television crews and several print reporters were. Alternate juror Paul Novak rose to read a rhyme when a judge might have, under different circumstances, read a sentence.
Of all the cards dealt to you over the past year or two, none have been the aces. Tonight, collectively, we ask that the cards be reshuffled, but this time, make the deuces be wild, and may all the aces be passed along to you.
Not only is it the first murder jury that's taken attorney Pat Piscitelli to dinner, but it's virtually unheard of in any case. Ron Sanders, News 7, Fall River.
Please, and spell for the court of work. Mr. Stephen Sims, S-I-M-S.
And your occupation, sir?
I'm a police officer.
And where are you a police officer?
That's a good question. Where am I a police officer?
In town.
In town.
How long have you been an officer, sir?
12 years.
With respect to December 29th, 1981, were you on duty that evening?
I was.
And where were you patrolling?
I was patrolling a residential district on the south side of town.
And at approximately 1:43 that morning, did you make an observation with respect to an area of that portion of the city?
Yes, I did. We were traveling in a patrol car with my partner south on Fairfax Street, and we observed a car parked with the engine running, the lights off, at the corner of Fairfax and Elm.
Your Honor, may the officer go to the blackboard for a moment, please?
Sure.
Officer, could you just place on the blackboard a general diagram of the streets in that area with a designation from north, south, east, and west?
No, you can erase it.
Calculus. This is Fairfax. Our car was traveling south on Fairfax at the corner of, I think I said Elm, it was Cornell Street. There was a car parked headed this direction.
That is the east direction, sir?
Yes.
Can you put an E to the right over there? And above north? And just, okay, where, and what did you observe, relate to His Honor, the jury, what you observed as you were coming south on Fairfax Street?
As we were traveling down Fairfax Street, the car that was parked at this corner, as I said, with lights off, engine running, with someone sitting in the driver's seat, upon the approach of our car at about a little more than less than a block's distance away, started the car, pulled around the corner, and proceeded down Fairfax Street.
And who were you with, officer?
With my partner, Officer Norman.
And who was driving?
I was driving.
And at that time, what did you and Officer Northern do?
We put on the lights and proceeded to give chase.
For how long?
Perhaps 8 or 10 minutes.
Okay, can you relate to the jury what happened during the course of that chase?
The suspect car proceeded at a high rate of speed down to Fairfax.
The high rate of speed will be stricken.
Officer, how fast was your car traveling? Do you recall?
We were cruising at perhaps 20, 25 miles an hour and had to accelerate quite a bit in an attempt to catch the suspect.
In your best judgment, what rate of speed did you accelerate to?
We probably reached perhaps 50, 60 miles an hour.
Okay. And then what happened?
The car proceeded south for several blocks, turned right on Dartmouth Street. We were in pursuit and closing at that point. Proceeded up to 1 block, turned right again on Elm. And as we followed at the next block and around the 800 block, as I recall. Suspect car pulled into a driveway, collided with a parked car in the driveway. We were right behind, pulled up in the driveway, and suspect left the car. I pursued.
As he left the car, what, if any, observations did you make, officer?
Well, this was the first opportunity I had to see him, and he was in the headlights of the car. I saw a man of medium height, medium build, and very dark pants, a dark brown jacket, possibly leather, dark bushy hair, dark complexion.
And when you say, how did he exit that vehicle he was in? Just relate to the jury how he left and how you observed him at that time.
He flung open, left open the driver's side car, exited, ran north, parallel to the house, which he had to do, and so was running from right to left across the line, my line of sight, in the headlights of the patrol car.
Okay. As that happened, what did you do, officer?
I exited the car and followed on foot, pursued on foot.
For how long did you follow?
About a block and a half, 2 blocks, I would say, and then he went over fences behind the house in the alley paralleling Fairfax and Elm Street, and I lost him.
What did you do at that time?
We had called in a chase previously. We returned to the car and began to patrol the area, watching for opportunity to see the suspect.
And later on that evening, over the course of the night, can you relate to the jury what happened?
Yes,
I would object, Your Honor, to broad question as to the law for narrative. Objection, please.
Objection sustained.
At some point later that evening, did you see the suspect that you had observed earlier?
Yes, I did.
Where was that?
He was in the back seat of the assisting patrol car.
And at what time was that, officer?
It was, I would have to refresh my memory, but I would say within half an hour.
Do you have your report with you?
Yes, I do. Yes, that was approximately 15 minutes later.
At what time?
2:10 a.m.
And at what time was it that you had radioed your assistance?
15 minutes previously at 1:55 a.m.
Okay. And do you see that individual in the courtroom today, officer?
Yes, I do.
And where is he seated?
Seated right there.
May I just have a moment, Your Honor?
Yes.
I have no further questions.
Okay. You may be seated, sir.
Officer Sims, you've been a police officer, you say, for some 15 years, is that correct?
12 years.
12 years. Good. And in the course of those 12 years, I take it you participated in many investigations, have you not?
That's correct.
And I take it that you participated in many arrests as well, have you not?
Yes, I have.
And his police procedures are not to make up a police report concerning the incident which you are reporting.
Yes,
right?
it is.
And I take it that that's what you did in this case as well, make up a police report, did you not?
Yes, we did.
Right? And you brought that with you, and that's what you used to refresh your memory a moment ago?
Yes, sir.
Now, that is signed by you as well as Officer Northern, is it not?
That's correct.
So I take it that both you and Officer Northern concurred in that report prior to the time it was placed in some written form, right?
Yes, we did.
And how soon after the incident did you commit that report to a written form, a typewritten form?
It would have been at the end of our tour of duty that evening. Which
and your tour ended when?
At 6 a.m.
So I take it then that you would have committed what you had observed and what had transpired within a matter of 4 hours after the incident occurred, right?
That's correct.
I take it you saw my client, to say, at 2:10 a.m. that morning, right?
That is right.
All right. And in committing that, what you had seen to written form, I take it you tried to be as comprehensive as possible and to put as much of the relevant and important facts that had occurred in that report, did you not?
Of course.
I take it you knew that sometime you may have to testify in a court of law concerning what had happened, right?
Yes.
And I take it you did all you could to be as accurate and as comprehensive as you could.
Yes, sir.
And of course you did that at a time that was fresh and vivid in your mind, right?
I did.
So it's fair to say that what's contained in that report would very accurately, as best as you were able, describe what had taken place just 4 hours prior.
That was our effort, sir.
And at some time, strike that, did you make any written notes concerning that, or simply make up a typewritten report?
I'm not certain what time you're speaking of. Notes.
Well, you said at 6 a.m. you made up a written report, correct?
Yes.
Did you type it yourself, or did you make up a written report?
I typed it myself.
You did. And again, both you and Officer Northern signed that report.
Yes, he read it over and signed it.
And he as well concurred that it contained all the important facts which you had both observed that evening, right?
Objection.
I'll hear you.
It's conversations, hearsay. Getting into what was discussed.
All right, well, objections sustained. Disregard the comments relating to the other officer.
But you want to be sure that you had all the important facts contained in that report, right?
I did, yes.
And I take it you read that report before you took the stand here today to testify in this case, did you not? To refresh yourself.
Yes, I did.
And is it fair to say you read the report some 15, 20 minutes, half hour before you took the stand?
Perhaps longer than that.
All right. How long did you say? An hour?
An hour, yeah.
Fine. And I take it if, in fact, you saw something in that report which needed correcting, you would have made those corrections, would you not?
Yes.
Huh. Now, as I understand it, you say that you observed a car parked at the corner of Cornell Street and South Fairfax as you were proceeding down South Fairfax, right?
That's correct.
At that time, the car took off and went towards South Elm, right? And you engaged in pursuit.
Yes.
And at some point, the car ended up hitting another car in the driveway at South Elm Street.
On South Elm Street, yes, sir.
How long did this chase take place, from the time that the car started to the time that you stopped your vehicle?
I couldn't be exactly.
What's your best recollection?
Perhaps 10 minutes, perhaps less.
At what time did the chase start?
Around perhaps 1:45, a few minutes before.
And at some point, you saw the car strike another car, correct?
Yes, sir.
And how far behind that vehicle were you when that took place? In feet.
I would estimate less than 150 feet.
And you then proceeded to come up close to the back of that car, did you not?
Yes, we did. We
drove up behind it,
yes.
Right? And how close was the bumper of your car to the rear of that car when you brought your vehicle to a halt?
We didn't pull up directly behind it. We pulled up at an angle to it.
How far distant were you at that point? 10 feet?
How far distant? Less than 10 feet, perhaps 3 or 4 feet.
And you say at that point, you noticed somebody come out of the car, driver's side, and race in a northerly direction, right?
That's correct.
And the person who came out was running at that time, was he not?
He was starting to, yes.
Fair to say that he bolted out of the door at the time?
It's accurate.
Flung it open?
Yes.
And did you see where, as he pushed the door open, he placed his hand on the door as he flung it open?
And my recollection is he threw it open with his right hand.
Whereabouts on the door did he have his hand, do you recall?
Look, I really can't recall.
Was it fair to say that he placed his hand on the door at some point and flung it open, right? You saw that?
I really cannot recall it. All I saw an arm fly out and the door opened.
And is it fair to say that he was at a profile view at that point when that happened?
Yes.
And did he run around the front of his car or the back of his car at that point?
No, he ran away from the car.
Away from you?
Northerly direction.
Right. In other words, his back was to you as he then took off, away from the direction of the cruiser.
Not so.
He didn't run toward the cruiser, did he?
He ran at right angles, somewhat oblique to the left of the cruiser.
All right. So is it fair to say that if you were sitting you were driving that night, were you not?
That's correct.
If you were sitting in the driver's side of your cruiser, and I'm in the car in front, that person you saw took off in this angle, right diagonal, right? Is that a fair description of the direction which you ran?
No, sir.
Well, would it be this way?
No, sir.
That way?
Not quite.
Well, am I right facing the way in which you ran?
No, if you would turn to your left, sir.
Are you starting to reach that
A
point
little
where...
more, a little more.
Right here?
Perhaps we're about there.
Okay.
That would be good.
And he jumped out and ran off to your left front, right?
That's correct.
Do you have your high beams or low beams on?
High beams.
Do you recall that?
When giving chase, you usually put on your high beams.
All right. And you were looking at him through your windshield, right?
And...
Now, please.
Yes.
You were look...
Initially, yes.
The windshield clean or dirty that night?
Always clean.
Always. And as he exited the car, it was at that point, strike that. How far was he when he left, or she, when he left the door of that car from where you were sitting?
No more than 15 feet.
I'm sorry?
No more than 15 feet.
15 feet. Well, didn't you say that you were parked 10 feet beyond him when he exited the car?
No, I did not.
Well, how far were you parked, your bumper, from his vehicle?
Our right front bumper was, I would say, within 3 feet of his left rear bumper.
So that 3 feet distance separated the bumper from his car, right?
Yes.
And you say that at that point you saw someone in the headlights of the car? Is that what you told us, Jerry?
I saw someone?
Yeah, in the headlights of the car. That's the first time you really saw the person, right?
That's correct, yes.
And you saw him at a point where your car, your bumper, was 3 feet away from the car, right?
Yes.
And was the car, your car, strike that. May I approach the Dr. Rowe?
Yes, sir.
Officer, assuming this is your vehicle here, and you're sitting right here, was the vehicle in front of you in a position such as this?
No,
3
sir.
feet separating?
No, sir.
All right, would you place it on the board as to, assuming this is your vehicle, may the witness approach the...
Yes.
Would you place a diagram as to...
This is an odd-shaped car, but
just place it on there, please.
that's a car shape, then his would have been like this.
Huh. And would you place the line as to his direction of travel at the time he exited the car? Okay. Amen. And he came out this door here, right?
That's correct.
And you say 3 feet from here to here? 3 feet?
Yes.
Ah. And is it fair to say, then, that you got a view of him which was this way, as you're facing me, this type of view of that person, right?
A little better than that, but essentially, yes.
And was he running at a gallop, pretty fast?
Pretty soon he was.
Well, when he got out of the car, he's running fast, wasn't he?
He has to start from a dead stop.
Well, you were in a Mark Cruz at the time, were you not?
I'm sorry?
You were in a Mark Cruz at the time, were you not?
Yes, I was.
With the siren blaring and the red light flashing, right?
Yes, sir.
No question that you were a police officer at that time, was it?
I shouldn't have thought so.
And at that point, you radioed in, did you not, that there was a chase in progress, or the suspect had left the scene, correct?
Not at that point, no, sir.
Well, is it fair to say, at some point, he left your sight entirely from the time he left the car to the time he disappeared? He disappeared after 1 or 2 seconds, is that fair to say?
Perhaps a few seconds longer.
Well, 3 seconds, is that fair?
I would say 5.
5 seconds, all right. So how far was he from where you were in the car 5 seconds later? 50 feet, 100 feet?
More than 100 feet.
150 feet?
Yes.
So the course of 5 seconds, he had traveled 150 feet before he disappeared from your view, correct?
Yes.
And you say that what you then observed was a person who had a very dark pants on, and strike that. Describe his appearance at that time, dark pants, and a possibly leather jacket?
Dark brown jacket.
And
Leather.
did you notice anything about the collar which is unusual?
I don't recall.
You didn't by any chance see a fur collar about that man's...
I don't recall a fur collar, no.
But you had a 5-second view of him, did you not?
Yes.
And how long is your car? How long is that cruise? About 17 feet?
Approximately, yes.
And you were sitting in here, would be about 7 or 8 feet back from the front of your car, right?
Yes.
And the car he was driving was about 17 feet long too, right?
Right.
So that if you were sitting 8 feet plus 3 feet distance, 11 plus another 7 or 8, you were about 20 feet away from him when he exited the car and bugged out, right?
Somewhat less.
Well,
7,
18 to 20 feet away?
17, 18 feet, yes.
Right. So the first time you saw him, he was 20 feet away, running over 5 seconds for 150 feet before he disappeared from your view, right?
That's correct.
And this is fair to say, Officer Sims, was a dark area, right?
Yes, that's true.
There were no street lights around there at the time of that driveway, were there?
Not in the immediate vicinity.
Right. So the only lighting you had from which you could observe the characteristics of the facial features of this person that you saw exiting that car were from your headlights, which were some 3 feet away from the back of his car, right? High beam or low beam, right?
There were...
No, please, is that correct?
No, it's not correct.
Where was the nearest street light, if any?
My recollection is it must have been 100 yards further north.
So is it fair to say then that it was a very dark area and the only lighting from which you could observe the person exiting the car was from your headlights, whether they be high beams or low beams?
That's correct.
Huh.
They weren't pointed at the rear of his car.
Will that be strict as our responsible for Jones?
May I go out?
And then the jury be instructed to disregard.
Yes, the jury should not take into consideration any testimony which has been stricken.
Now, you say at that time that you then took up chase and ran after it for a couple of blocks, right?
Yes, sir.
Well, that's not what you said in your report that you filed on 6 a.m. on the morning of December 29th, was it?
Is it not, sir?
No, that's not what you said, was it? You said Officer Northern was the one who chased him for a couple of blocks, didn't you?
That would be incorrect.
Well, did you not say, whether it's correct or not, didn't you, in your report, which you told us you put down at a time that's fresh in your mind, facts were vivid, didn't you say, Officer Northern followed the suspect for a couple of houses north of accident scene and lost him? Did you say that?
May I check my report?
Sure, go right ahead. Check the second paragraph, midway through. Let me point it out to you. May I approach the screen, please?
Yes.
Yes, indeed, that is what it says.
That's what you said. But that's not what you told this jury today, is it?
No, it isn't.
You told this jury that you were the guy that ran after him for a couple of blocks, right?
That's right.
So that's not true, is it?
No, it's not.
You just forgot, right?
It's confused, yes.
Well, didn't you tell us that you read over your report just 1 hour before you took the stand today to refresh your memory?
Yes, I did.
And in that hour, you've forgotten that it was Officer Northern that chased him 2 blocks and not you? Hmm?
I didn't notice it.
By the way, did you take the registration number of that car down at some point?
Yes, I did.
And what was it?
BD 4563.
4563. Well, as a matter of fact, that's not the registration number that you indicated in the first paragraph of your report.
You're right.
Is it?
No, it isn't.
You said it was 5663, BD 5663, right?
That's what the report says.
That, too, is just a mistake, right?
Yes.
Well, didn't you tell me, too, that you looked over that report with Officer Northern? If there were any errors, you would have corrected them?
I would have hoped to.
But you didn't correct that one either, did you?
No, I didn't.
As a matter of fact, is it fair to say that in the paragraph next to last in your report that you said the registration of that car was 4561?
That is correct.
Well, which is it now? What registration number was it of that car? 4563, 5663, or 4561? Which do you want the jury to understand was the registration number?
BD 4563.
So that if you indicated it was 5663 or 4561, that too was incorrect, right?
That's right.
Did you review this report before you took the stand today, officer?
Yes, I did.
You didn't pick up that mistake either?
Yes, I did.
Well, you didn't correct it on your report, did you?
I can correct it.
My question, you didn't correct the report, did you?
I didn't have time today.
In the hour before you took the stand, you didn't have time to correct the report?
I corrected my copy.
How many cars were chasing that night?
Only one, sir.
Now, is it fair to say that, strike that, you gave a description of the person you saw as being a medium height, medium build, right?
That's correct.
And is it fair to say that in your report, you never made mention of that guy being a medium height, medium build? Isn't that correct?
That's correct.
You, for the first time, you're telling this jury today, 6 months later, that the guy you saw had a medium height, medium build, right?
That's correct.
But did you tell the jury that you put all the important and relevant facts in your report at the time that you committed to a written form at 6 a.m. on December 29th?
I tried to, yes.
Well, wasn't it important that you put down that the guy was a medium build and medium height? Would that be important?
I can't answer that, I'm afraid.
Well, officer, isn't the identification of the suspect one of the most critical aspects of the case?
Yes.
Well, would you concede that whether he was 6'9" or 4'7" would be important?
Of course.
And whether he was of gargantuan height or whether he was a gnome would be important, right?
Didn't seem
Right.
to be a question. Yes, yes.
But you made no mention that that guy you saw was a medium height, medium build in that report, even though you say it was important, right?
So it would seem.
Huh? You didn't just say that because my client looks like he's a medium height, medium build, did you? Hmm?
No.
Did you? No.
No.
And both you and Officer Northern collaborated in writing this report, correct?
Yes.
And he didn't mention it either, did he?
No, he didn't.
He was there with you, wasn't he?
Yes, he was.
Now, is it fair to say, strike that, at some point, Officers Northern and Lewis came back with someone in their cruiser, correct?
Excuse me, sir.
At some point, Officers Northern, strike that, Officers Lewis and Osborne returned to South Elm Street, where this incident had occurred, with someone in the back of their cruiser, correct?
That's correct.
At what time did they arrive back?
Somewhat after 2, about 2:10.
And you saw someone in the back of the cruiser at that time, right?
Yes, I did.
And both you and Officer Northern were there at the time that Lewis and Osborne returned, correct?
That's correct.
All right. And it was my client sitting in the back seat of that cruiser all alone, wasn't it, that was brought back to the scene, right?
Yes, it was.
And you identified him at that point, did you not, as being the guy that you'd seen run away from that car just a matter of 15 minutes earlier, right?
Yes, I did.
And my client, look, may I stand here, please? Would you stand, please? My client, Mr. Berg, is it fair to say, had the same mustache that night that he has today, right?
Yes, he did.
But you didn't mention that he had a mustache in the report when you saw that person running from the car, did you?
I don't believe I could have seen it. No, I didn't.
Well, you saw that he was dark complected and black bushy hair. Did you say that, dark bushy hair?
Yes.
Would you say that my client has dark bushy hair, black bushy hair?
Yes, it would.
You say that's dark bushy, black bushy hair?
Yes.
Will you turn around, please? You call that black bushy hair?
Yes, sir.
Would you say that my hair is longer than his?
Yes.
You consider me as having gray speckled black bushy hair too? Would you?
Wavy, I would say.
Was it black and bushy, dark bushy?
No.
And you said that you were just a matter of 18, 20 feet away and you didn't see that that man had a mustache, the guy that you saw running off?
That's correct.
All right. And you noticed too that when he was in the car, he had a fur collar around his coat, didn't he?
I don't recall.
You don't recall the person who was brought back as having a fur collar around his leather jacket? You recall that?
I really don't know.
Well, didn't you tell me you read your report again 1 hour before?
Yes.
And did you put in your report that the man who was brought back by Officers Lewis and Osborne had a fur collar around his coat?
Yes.
You did, you remember that now?
Yes, that's it is in the report.
And you put that down at a time when this was vivid and fresh in your mind, right?
Right.
And now 6 months later, you don't recall?
I'm afraid not.
Well, which is it now? How do you believe the jury? That he had a fur collar around his coat or didn't have a fur collar? Which is it?
I have to believe he did.
But the guy that you saw running off didn't. You didn't observe the fur collar, did you?
I don't recall that he did, no.
And he had a light fur collar 4 inches wide and even wider around that coat, didn't he?
Apparently so.
And there wasn't more than one person back of that car, just my client sitting alone, right?
That's correct.
And at that time, you interrogated him, did you not?
Yes, we did.
By the way, did you notice my client at that time was wearing black bell-bottom trousers?
Yes, he was.
But you didn't tell us that the guy you saw running off had bell-bottom trousers, did you?
No, I did not.
And if you'd seen that, you would have put that in the report, wouldn't you?
Presumably so, yes.
And would you say my client looks Negroid?
Yes.
That's how you describe a person with Negro features?
Yes.
And is it fair to say that the guy you saw that came back in the car, Lewis and Osborne, had a suede jacket on?
That's correct.
You said in your report there's possibly leather, right?
Yes, sir.
And you spoke to this person at the scene, and he answered your questions at that time when you asked him where he'd been, right?
That's correct.
And he denied any knowledge or involvement in this incident, did he not?
Yes, he did.
As a matter of fact, he told you where he was.
Yes, he did.
Right? He told you he was watching TV all evening at the home of 2 friends, right?
That's correct.
And you learned that they had brought him back from where he was found sitting on a porch. Right?
They?
Lewis and Osborne brought him back from a porch they found him sitting on.
Yes,
right?
That's correct.
And it was a lit porch he was sitting on too, wasn't it?
Objection.
Sustained.
Well, did you inquire as to whether or not it was a lit porch on which he was sitting?
No, I didn't.
You don't know that?
No, I didn't.
And to this date, you didn't determine or inquire as to whether or not he was sitting on a well-lit porch at that time of the day?
Sustained.
In any event, you even went back and talked to these 2 people whose names he gave you, right?
Yes, we did.
And they confirmed what he said,
Objection.
right?
Sustained.
Well, as a result of the conversation, strike that. Did you summon those 2 people in here whom you went to talk to?
Objection.
Sustained.
If you know, are they available to testify here in this court today?
Objection.
Sustained.
Now, I assume you searched my client that time as well, did you not?
Yes, we did.
And you found he had $3 and a pair of rosary beads on him, right?
Among other things, yes.
And that's all you found on him, right?
Essentially, yes.
And you searched the car too, right?
Yes, we did.
And you found pencils, a Bible, and your other odds and ends, right?
I don't recall the Bible, sir.
And you remember the rosary beads?
That's correct.
And I suppose, strike that off, sir. You went back to the location where the car had been parked and you first observed it, did you not?
Yes, we did.
And nobody was home at that house that you went to, right?
Right.
What did you arrest my client for that night? Burglary?
Yes.
Of which house?
Of the house adjacent to where we originally saw him parked.
But you said you went back there, no one was home, right?
Right.
So you don't know whether or not anybody was in the house, and strike that. You had no one to talk to concerning what had occurred at that house before you placed my client in arrest, right?
No.
Right?
Correct.
But you arrested him for burglary.
That's right.
By the way, did you take my client's fingerprints when you booked him down at the station?
Did I take his fingerprints?
Did you have his fingerprints, you or someone at your direction, have his fingerprints taken?
Yes.
And I assume you compared those 20 fingerprints you found in the car?
Yes.
And you have results of that? Strike that. And you found that my client's fingerprints don't appear anywhere in that car, right?
That's right.
And despite all of that, you brought my client in and arrested him and charged him with burglary, eluding a police officer, despite all that. Right?
I'm sorry, despite what, sir?
Despite the fact his fingerprints didn't appear in the car, and he had found nothing that was of stolen merchandise on his, on him or in the car. You arrested my client for that, right?
Yes, sir.
I have nothing further. Thank you, officer.
Will you redirect?
Did you notice, officer, if the individual you observed that night was wearing a pair of gloves while he left the accident scene?
No, I did not.
Didn't make any observation of him discarding a pair of gloves at any time?
Did not.
Officer, who pursued the suspect after the accident? Was it
I
you?
did.
You pursued him?
Yes, I did.
And when you went back to the scene where you first observed him, did you at some point conduct an examination of the house?
Yes, we did.
And what did you observe with respect to the house?
Detective...
Objection, please, Your Honor.
I'll hear you.
Please, I will simply ask him whether or not he had talked to him at the house, not whether he examined the interior of the house. This is something new on redirect.
Well, you've raised the question of whether or not there in fact was a burglary known to the officers. Objection overruled.
What did you observe with respect to the house?
In the company of Officer Norman and Detective Housegood, we inspected the house and found the back door pried open.
And at some point, did you go and make an examination with inside that house?
Not at that time.
At some point after that?
I did not, officer.
Now, if you can, officer, relate the description that you first gave of the suspect after you had pursued him, after he had stopped after the accident. The description you first gave of the suspect. Can you relate that, please?
My objection, please, Your Honor.
I'll hear you on that.
I believe you've already given that, and why it's going to get it.
Well, there's been few questions into that, so I'm going to allow redirect.
Could you repeat the question?
The description that you first gave or had observed when you observed the suspect exiting the vehicle. Can you relate that description, please?
He was wearing dark pants, a dark brown, possibly leather jacket, and bushy black hair and a dark complexion.
And anything else you recall about what race he was?
Is there anything I recall about what race he was?
In terms of the description that you gave?
I believe I said possibly Negro.
And to the best of your recollection, that's what you related in your report that evening, correct?
That's correct.
And that was your best memory of it, correct?
Yes, it was.
And can you relate to His Honor and the jury how the suspect appeared to you when you observed him in the vehicle, the police vehicle, at 2:10 that evening?
He answered that description.
And with any change at all, officer, was there some other... Strike that. To recall the description that you placed in your report that evening.
The description?
Of the suspect when you observed him in the police cruiser at 2:10.
Yes.
And what was that?
That he was wearing dark bell-bottom trousers, a suede jacket with fur collar.
And what kind of coat did you describe it as? What kind of coat did he have on?
Did he have on in the patrol car? A suede jacket with a dark fur collar.
Okay. And officer, do you know where 985 Elm Street is?
Yes.
And how far is that in relationship to where you pulled your cruiser up behind the car of the suspect? Good.
Less than 2 blocks.
Okay. Anything else you would do on direct, redirect?
No, just, officer, is there any doubt that this individual is the person that you observed exiting the car that evening?
My objection, please.
I wasn't quick enough?
It was overruled. I think you could...
You can answer. Okay.
Yes, that's him.
That's it. Put the cuffs back on. Okay. Fantastic.
Highest court to fight what she calls discrimination in the prison system. 39-year-old Marianne Chisholm is serving time at MCI Framingham, the state's only prison for women. She says that female inmates, unlike male inmates, are not allowed to participate in work release programs. But Chisholm says the suit is really for the children of imprisoned women.
Being harassed in school. My daughter and my two youngest sons, their grades are dropping, and they don't want to go to school. My mother is having a hard time handling them.
And the solution is to get you back home?
Yes.
That my client should be released immediately back into a society pending they're doing something right. Plus the fact that this is a suit brought for the children of my client and a class action based upon her representing the children of all female inmates who are in the same position.
Chisholm is serving a 3 to 5 year sentence on drug charges. Her suit will be heard before the state Supreme Judicial Court tomorrow.
5 young Holbrook men are celebrating tonight in perhaps the most publicized rape case in recent state history. The so-called Holbrook 5 were acquitted on Friday. The 5 accused of raping and assaulting a woman 3 years ago pleaded guilty the first time around, received a suspended sentence, but after a public outcry, the judge reversed himself and ordered a trial. Tonight that trial is over and the jury found the men not guilty. We have 2 reports. First, from News Center 5's Jack Harper.
Is Mr. Tarr guilty or not guilty? Not guilty. Quiet, please. Mr. Foreman.
The first not guilty gave Robert Tarr and the others a chance to take a breath. They would all be cleared of 2 counts of rape in the incident in Holbrook in 1980, in which the 5 had sex with a Whitman woman. It came down to the jury not believing the state's star witness, Christian Dixon, who had also had sex with a woman, but who testified with immunity.
I think they would have had to completely disregard Dixon's testimony in order to arrive at the decision they did, yes. I expected a guilty finding, but that's the glory of our system, is that the jury makes the decision and not the prosecutor or other individuals, so.
For the young men known as the Holbrook 5, it's over, 3.5 years after the incident.
I feel excellent.
Put your hand up again.
Nah.
Were you surprised at all by the...
No, not at all. Not at all.
Mr. Foreman, what say you to indictment numbered 76316, charging the defendant Richard Dovell with the commission of rape? Is Mr. Dovell guilty or not guilty? Not guilty.
Just totally relieved. Come on, please.
Did you have your doubts along the way, or?
Never.
What do you say to an indictment numbered 76312, charging the defendant, John Strickland, with the commission of a rape? Is Mr. Strickland guilty or not guilty? Not guilty.
Oh, no doubt. It's a piece of cake.
What say you to an indictment numbered 76308, charging the defendant, Mark Savoy, with rape? Is Mr. Savoy guilty or not guilty? Not guilty.
Relieved.
Only Al Adopoulos was not in a talking mood. Because of pretrial publicity, this jury was selected from the Springfield area, and the jurors went back to the western part of the state without explaining their decision.
Mr. Foreman, can you talk to us at all, sir?
Each defendant was convicted on 1 charge of taking part in smashing up the Whitman woman's car. But even the prosecutor left saying they won't serve a day. They're free men. Jack Harper, News Center 5, Dedham.
This is David Ropeek. The party began almost as soon as the defendants could get into more comfortable clothing and gather their friends around them. There was champagne and beer and relief.
To my mind, I felt relieved. You know, my hardest 5 minutes of my life. I was scared. Naturally, anybody would be, but I did feel confident because we believed in ourselves, and our friends and our family and our lawyers all believed in us, and I think that you can't lose with that combination.
How'd you feel when they said not guilty?
Yeah, I did feel good. I felt like crying, basically, just out of relief.
Everybody knew I was not guilty. Everybody that knows me knows I ain't capable of rape. You know, I mean, that's one of the worst crimes in the world, and I'm not capable of that. You know, I'm not an animal. I'm not an animal, you know? And everybody made me out like that, but I'm not.
Also at the party was the father of defendant Mark Savoy.
Always rough for everybody. Yeah, all the kids, you know, from the oldest to the youngest. They all had a hard time one time or another, but for sure they're all over it today, you know. We're all back together.
There is, of course, another reaction tonight to the verdict. As this party was going on in Holbrook, the woman who says she was violently gang raped spent the night quietly with her family in western Massachusetts. Efforts to reach her for comment were unsuccessful. In Holbrook, David Ropeek, News Center 5 Tonight.
Good evening. Widespread reaction to the surprising not guilty verdicts in the so-called Holbrook 5 case continues today. In an exclusive letter given to News Center 5, the woman who accused the young men of rape expressed her feelings. News Center 5's Jack Harper has details.
The celebration by the Holbrook Five lasted late into the evening. The 5 young men charged in the assault on a Whitman woman in January of 1980 were all smiles. They had been found innocent of rape and will probably receive suspended jail terms for vandalizing the woman's car. For the Holbrook Five, it's over. But for the woman who says she was raped, the anguish goes on. That woman's husband today provided News Center 5 with her reaction to the verdict. I only wish the judge, defense attorneys, the parents of these young men, and the 12 jurors could have been there that night to experience the true terror and horror of what occurred. I was left to die, naked, my car destroyed, not even knowing where I was, and in a terrible state of shock. During those horrible hours, I was just trying to stay alive. Physically, I did survive. Mentally, I'll never be okay. If I had died that night, I honestly feel now that the verdict would still be the same. The reason I did not testify is because of my doctor's advice, whom I've had to see every week since the rape occurred. They have ruined my life. I'm not able to work. If I were able to go to court, there would have been only guilty verdicts. There's only one that is innocent, Christian Dixon. He's the only one who helped me. Did you believe her?
Yes, without question.
You still believe her?
Absolutely, without question. It's a terrible tragedy. I'm part of the criminal justice system. I believe in the system. Unfortunately, we have cases that end up this way.
Justice has failed. There's no way I would have gone to the police if they were not guilty. No wonder women hesitate to report rapes. I'm very angry because they are guilty, and they know it.
She feels that nobody believed anything that she did or said or the like of that, and that she was just no good, and she just feels left out in the cold as she was that night.
Jack Harper, News Center 5, Dedham.
Nobody believes.
Finding cases where your client is known to be involved in a case which you think you might lose is to keep him out of jail. So that if you are pretty much convinced that a plea will do it, why, that's the way you go. You tell him what the chances are.
District Attorney O'Malley talks about guilty pleas which occur without using the bargaining process.
Of all the cases that come to a final conclusion, the overwhelming majority are convictions as a result of a plea of guilty. It's something that I don't think the public understands, that anywhere from 3/4 to 90% of all defendants plead guilty. In Plymouth County, it is somewhere between 85 and 90%, not as a result of plea bargains, but because they know that they are guilty, they know that the Commonwealth can prove they're guilty, and they know that they are apt to be punished more severely if they have a trial and all of the evidence that is developed in the course of a trial that might last 2, 3 days or a week is being considered. The chances are that they will be punished more severely.
Judge Prince speaks about his own unique view of the plea bargaining process from the bench as an observer rather than a participant.
Judges do not participate in plea bargaining, at least I don't. And the district attorney and defense counsel work together, trying to reach what they believe to be a fair settlement for both sides. In other words, they may feel that because their man is doing time, that at least part of the sentence should be concurrent, meaning run along with the time he's already doing. And that will make a difference, and the disposition of the case may differ because it's to the district attorney's advantage. they have mutual reasons why they want to discuss pleas of guilty. But I would like to point out at this point that we do not control the sentences in terms of pleas, the same way that we do a trial.
As a matter of policy, we will not negotiate a trade whereby, in consideration of a plea of guilty, we'll lower the recommendation we're going to make to the court. We just don't do that. That has not affected the rate of pleas of guilty.
Now that's considered plea bargaining, isn't it? When a defendant will agree to plead guilty and the prosecution will agree to ask for a lighter sentence, that's considered plea bargaining. Your office does not participate in that?
In cases in Superior Court, which are the most serious cases in all the cases of violence, we will not plea bargain. We will not exchange a lowered sentence or a lowered charge for a person pleading guilty. If they want a trial, we're prepared to try the case and let the chips fall where they may. If we get a conviction, we're going to make the recommendation that we think is right.
Why is that your office does not participate in the plea bargaining procedure?
Basically, as an attorney elected by the community to represent the community's interests in a criminal case, I believe that the public confidence in this office and the public confidence in the system is vitally important.
If I think the chances are of Ivory Soap's certainty that he may get hooked on a case, and I can make an agreement in advance that he not go to jail but plead and beat his breast 3 times and say I'm sorry for it, why, I would certainly decide to go that way and advise him that that's probably the best way to go. Those are the times that you would strongly seek out a plea bargain which results in a plea and disposition without jail. Those cases which are very compelling against your client. In some counties, you find it's very difficult to engage in plea bargaining because you find that the DAs are difficult to deal with in the respect that they tell you that they will recommend very harsh sentences if your fellow pleads. And the purpose of plea bargaining, in my estimation, is to try to work out a middle ground between what the DA thinks your fellow should do and what you think. And obviously, you think your client's innocent, your client professes innocence, the DA professes his guilt, or says or opines that he's guilty. And I found in some counties, and notably in Plymouth County, for example, their recommendations are very high.
When they're before me, there's only one job for me to do, and that's get the case tried or dispose of it by accepting a plea of guilty and making a sentence. And that's what I try to do. We have an awful lot of them, and whether we like it or not, plea bargaining is a necessary way of keeping the list moving. Otherwise, we'd be far, far behind.
Tomorrow's segment will deal with the process of the criminal trial itself.
Of the victim and the manner in which cases here in Massachusetts of the relationship with those trials and the press's right to report on those trials. That's the tenor of our discussion this morning, and we'll get into it right after this.
So you made your home in New England.
Now, as our weekend editor, Gloria Chun, Gloria has prepared a report for us on the crime of rape here in Massachusetts and the manner in which we try those rape cases. Gloria, I understand we're going to see a personal side of the crime tonight.
Right, Dave. I talked to some rape victims and wanted to know their feelings about the rape shield law and about publicity and how that affects the trial. Here now is my report.
Rita knows the meaning of the word victim. 30 years ago, she was molested by a stranger who broke into her home and raped her 8-year-old sister. 18 months ago, she discovered that her 2 stepdaughters had been raped over a 4-year period by a family acquaintance. The rape case involving Rita's stepdaughters took 11 months to come to trial.
I felt like I was being, this is going to sound dumb, put on trial, but in front of thousands of people. Because the way he was asking the questions, the way my attorney was asking questions, I had no problem. But the other attorney, when he was asking questions, I didn't understand them, and so that made me frustrated. And I was frustrated that I even had to go through all this, because, you know, why couldn't they just believe me? I can remember I was shaken.
In the case of the girls, I can remember when Beth told me, her world fell apart because of what happened. She was robbed of her innocence. She was victimized, in my senses, twice by the actual judicial system. The fact that we had to wait in the same waiting area as the defendant and his witnesses, what the defense attorney put her through on the witness stand in trying to confuse her. And I got this after the trial from my attorney because I kept wanting to know why she was so hysterical.
The FBI estimates that over 3,600 women and children were forcibly raped in Boston last year. That's 10 assaults every day in Boston alone. Whereas statistics on rape are hard to come by because only 1 out of every 10 rapes are ever reported. Fear of publicity and very brutal courtroom cross-examination often keep the victim from reporting the crime. To encourage women to come forward with rape complaints, the Massachusetts legislature passed the Rape Shield Law in 1977. It prohibits any evidence of the victim's prior sexual conduct from being admitted into trial. Only prior sexual conduct with the defendant may be presented.
I think they've gone overboard in their enactment of the Rape Shield Law. Let me give you a specific example. In the Holbrook rape case, in which I defended one of the 5 boys charged with rape, we had evidence in that case that the woman involved had been at the bar some couple of hours before the young men had supposedly taken her to a wooded area. And the evidence which we had, which we produced for the judge and at an in-camera hearing outside the presence of the jury, was the effect that the woman, aside from trying to get on the bar and do a little dance, she has solicited sex from one of the patrons there by offering to go to a motel and using her American Express or a charge card of some sort. It would seem to me highly relevant and highly compelling that that evidence should come in to show that she was in a consensual state of mind. She wanted sex.
In the old days, you used to be able to ask her how many people she'd slept with, on what occasions, go back to her first boyfriend when she was 14 years old, and none of that has anything to do, no matter how much someone sleeps around, has nothing to do with whether she said yes or no or resisted on a particular occasion. And that's the fallacy. The argument is that if a woman has had relationships with a lot of men, she's more likely to have consented on a particular occasion, and that's a fallacy.
Another issue of protection for rape victims was brought to light in the recent Big Dan case. During that trial, at least 6 media outlets broke an unwritten rule by releasing the victim's name to the public.
Publishing a victim's name in a rape case is unconscionable. There's no way that I can see under the First Amendment that we can outlaw it, that it can be made a crime. But for years, it was understood among news people that it was not to be used. Unless a victim was a particularly well-known individual, it serves no news function.
It does violence to the presumption of innocence to say that we can show him as an accused perpetrator of such a heinous crime. At the same time, we can say that the person who alleges that he did that, who accuses that person of having done that, we're not going to show or let it be known what her name is. What it does is make it appear as if she's true in her accusation. What she's saying has a ring of truth about it.
I just don't think it should be publicized because I know how I felt. You know, I did not like it. I don't think that it's fair for us to have our names put in. You know, we're supposed to be protected by law. Then protect us and don't put our names in.
One of the things that bothers me about society at large is that they still consider the crime of rape as a crime of passion. So consequently, why not be able to bring up the prior sexual conduct of the victim? But it's not a crime of passion. It is a crime of violence.
A difficult, sensitive issue. Woman lives with rape the rest of her life, but how can we ensure a very fair defense for the assailant or the alleged assailant?
Well, that's the kind of question we're going to inspire here this morning, Gloria. Thanks very much for your report. And in just a moment, we're going to be beginning our debate. And we're going to have a pretty lively debate over that Rape Shield Law and some of the other items that were just referred to. Gloria will be back with me later on in the show, joined by our friends from the New England News Exchange. The editors of those papers will join us for a debriefing discussion. But in just a moment, right after we come back, the debate begins. Come on back.
These days, it seems...
Debate begins, and the subject this morning is the rape shield law here in the Commonwealth of Massachusetts and all of the ways in which we try rape cases here in the state. Now, our audience this morning is comprised of both police and prosecutors, defense counsel, rape counselors, people who've been victims of the crime of rape, and members of the judiciary here, in addition to members of the media. Oftentimes we hear outcries that there's altogether too much coverage, or maybe that the nature of the coverage isn't quite right, both prior to the trial and during the trial. Our special guests here this morning are the District Attorney, Public Prosecutor for Bristol County. He is Ron Pena, and he is here joining us this morning. Also is David Wexler. David is a defense counsel, and both of these gentlemen were rather prominently displayed during the Big Dan's rape trial, all of which you are very much familiar with, I am sure. Ron Pena, let's begin with you. Tell us what the rape shield law says and what it was meant to protect.
Well, David, back in 1977, the legislature passed a statute basically to protect the victims of rape when they came to court. And to summarize it very briefly, it says that any general character or reputation of the victim cannot be brought up in a court of law, generally speaking. Secondly, any prior sexual acts of the victim are not admissible in a court of law also, except that there are two exceptions on the statute on its face. One is if it relates to a specific act by the victim with the defendant in the trial. And secondly, if it's a specific sexual act which will show in evidence that there are some physical features or characteristics or well, basically characteristics that will become evident in the trial. Those are some of the exceptions to the specific acts. That's basically it on its face.
Okay. David Wexler, it all seems pretty reasonable as he spells it out. Why don't you think that it is as reasonable as he presents it to be?
Well, the general language of the statute, I don't have any objection to. I don't think it does more than codify what had become good practice of the trial bench in Massachusetts years before it. Namely, we exclude evidence that's not relevant, and certainly the general sexual history of a woman or her general character is simply not relevant to the case. The more problematic situation is when specific things that have happened do tie in, and the trial bench chooses to interpret the statute in such a way that it is given broad application that stops defense counsel from fairly confronting somebody who at that point is only a complaining witness, not a victim. Under our system, nobody is considered a victim until the jury renders a verdict, and that is the problem. All we have here is somebody who's made an accusation, and to protect her to the extent that somebody's ability to confront this person in front of the jury is limited, that's where the problem lies.
So you say the real problem then lies in interpretation and implementation versus the manner in which it was written. Am I right?
That's correct.
Okay. Let me ask, Sidney Hennell, let me ask you. I know that you have had a lot of experience in rape trials as a prosecutor, and in addition to that, you've been a strong supporter of this law. You've heard what David says concerning the interpretation of the law and its implementation. Do you agree?
No.
And tell us why.
I can't think of an example where the trial bench hasn't bent over backwards to give the defendant a fair trial. In my opinion, the law has been weakened at least twice by the Supreme Judicial Court, allowing evidence that would not have been allowed under the statute on its face, and the trend has been to weaken it, and mostly judges bend over backwards to let the defendant get in what he wants to get in.
So you think the defendant basically, in your experience at least, has gotten an eminently fair shake? You don't see any due process arguments or any problems concerning, you know, a defense counsel getting in an effective kind of defense?
No, because what they're trying to say is that a particular activity that somebody did at another time affects whether she's to be believed at this time.
All right, now that goes to consent sometimes, right? And sometimes we can say that an individual develops a habit pattern or a pattern of conduct, and the whole issue of consent comes up to how many times has she done this before?
But why is, because somebody slept with someone in a consenting situation, why is that relevant now when she's saying, I was raped, I was violated?
Are you suggesting that was relevant before? I mean, this was admissible before, and juries heard all this kind of...
I'm saying that a lot of it went in before. The best thing that the statute does, although it's not always honored, is that used to be defense attorneys could bring up stuff that was not admissible, but then it would be excluded, but the jury would already have heard it. The statute now requires them to make an offer of proof out of the hearing of the jury, so they can't slide it in the back door, which was done a great deal in the past.
Okay. Now, speaking of sliding things in the back door, there can't be a defense counsel in the United States of America that doesn't know a way to get around the rule If they write a rule of evidence, you fellas are usually looking for some sort of an exception to it. Roger Whitcomb, let me ask you, if you're confronted with that law and there's a piece of evidence you might want to get in, you may want the jury to hear it, what's the way in which you get it done if you can?
Well, it's going to depend, and in regard to the main issue, I had a case involving a girl who was on probation for promiscuity, and I was prohibited from showing.
When did that become a crime, by the way?
No, well...
Oh, there's a lot of folks watching
as
in.
a chins matter. It was a child in need of services on probation for promiscuity. It was in the record, and she had to comply with certain conditions. I couldn't get it in. Couldn't, back door, side door, or anywhere. I couldn't get it in.
Suppose you, I want to go back to what Sidney Handler said a moment ago. Suppose you could get it in. Suppose you were able to tell a jury, ladies and gentlemen of this jury, here's a woman who's been adjudged promiscuous in the courts of this Commonwealth, even though a juvenile. No wonder she's here today complaining about rape. Why is that fair?
It's fair because it allows the individual, the person who's on trial, to be able to show that the complainant, who isn't always, by the way, a woman, but in any case, the fact that in this case it was a young lady, that she was on probation for promiscuity, that I was unable to show that she had a long career of being promiscuous with everybody in town, denied this fellow, in my opinion at least, a fair trial, except for the jury verdict, which was eminently fair.
Okay, let me get to Judge Young if I can then. Judge, in terms of process, you've heard here the definition of the law, which you know well. You're the fellow who has to make the decision about whether a particular piece of evidence, in any case, ought to be admitted or ought to be disallowed. You make it on the judgment of what you think is fair overall, but what about this law? How do you respond to what you've heard so far?
I think the law was very carefully crafted. It is a question of interpretation, as has been pointed out, but as compared to a number of different evidentiary statutes, this one is very specific. So the range of discretion that's left to the trial judge is far more limited in this area than in others. And it seems to me that judges try to follow the law as it is set out by the legislature. There is one other dynamic, though, that should be mentioned here, because you won't get the whole understanding, I think, of what happens dealing with the rape shield law. And that is, behind it, is the right of confrontation, which is guaranteed by the constitutions both of the United States and of the Commonwealth of Massachusetts. That is to say that someone who is placed on trial and accused of a crime has a right to confront those witnesses who may be called to testify against that person and accuse that person. Whatever the rape shield law says, whatever the statutory law of this state or any state may provide, the Constitution is going to control that. So it's not only the interpretations of our state's high court, the Supreme Judicial Court. You have to look at the interpretations, constitutional interpretations, both under our state constitution and the United States Constitution. Those tend to be more subject to interpretation, more difficult to apply in any specific case. But if all we had was the rape shield law, it's a very carefully crafted statute. It's not for me to speak to the policy of it, but I say that it is not a statute that leaves you a great deal of discretion. It tells you when something can be admitted and when it ought to be excluded.
Okay, let me go to David Wexler on that score. Do you agree that the statute is very narrow and maybe a little inflexible? It limits the amount of discretion a judge has as to whether he lets in evidence A or he disallows it? Do you agree with that?
Well, I think those terms are relative. I think it's, though, fair to say that in interpreting that statute, intelligent people will differ. I might suggest that Mr. Piscitelli differed with another intelligent person, the judge in that case, the Holbrook case, as to what should be admitted. I think it's fair to say that defense counsel in the Big Dan's case may well have differed with Judge Young's interpretation. So I think it is broad enough so that there are questions that remain as to how rape shield should compare with the constitutional mandate that defendants have the right to confront witnesses. And in those close call situations, when judges err to protect somebody who is only a complaining witness, just another witness at that point, no finding yet by any public fact finder, I think that's where the problems exist.
On the one that Roger outlined for us, he said there was a past record of promiscuity. Forget the fact it was for a minor for a minute, all right? Do you think that's relevant? Do you think that's fair? As a defense counsel, would you want to make certain that the jury found that out?
Judge Waxler probably would have ruled the same as the judge in his case. That happens to be one point that he may disagree.
Okay, there's a lot of disagreement going on around here. Pat Piscitelli, before we move over to talk to some of the folks on the other side here, let me put the question to you. why is it fair to have certain items of the past conduct of a victim or a complaining witness in this instance? Why is it fair to admit those things, beyond the fact that you obviously are charged with getting your client off in this particular case?
Well, I'm of the mind, David, that the fact that a woman is promiscuous, assuming that she's the complainant, is of evidentiary value as to whether or not she consented. Of course, think about this. In rape cases, the only two defenses you've got really are, number one, I didn't do it, you got the wrong guy, or number two, I did it, but she consented. I participated in sex, but it was consensual, which is complete defense. And of course, if you are limited, if your only defense is consent, and you are limited in what you can show as inferring consent on the part of the alleged victim, then your defense is constricted. Your really only defense is dispossessed you, which is why I have some grievance with the rape shield law.
Why is it fair, though, if we say, for example, Mary Jones, we can prove to you, ladies and gentlemen, slept with 99 individuals in this community over the past 3 years. Why is that relevant to whether or not she slept in this instance consensually with John Doe?
Well, I think that that's a question of fact for a jury to know and to decide whether or not they can infer that in the 100th instance, she also consented to sleep with this particular person who's charged with the crime. It seems to me if someone does something repetitively over the course of time, it's likely that person will continue that pattern of conduct.
Okay, and that's one of the things, I'm sure, that a lot of people feel is the very reason why they don't report the crime of rape, because instead of being there then saying so-and-so has done me a bad turn, they wind up being on trial themselves, so to speak. Now, I know we have some folks here today who are victims of this crime, as I refer to you, and one of the things I want to dispel immediately is that you folks don't agree anyway that it's a victim. You say that you're a survivor of the crime of rape. Can I go to you on that particular point? Why is it important for us first to be survivors and not victims, and then try to respond, if you will, to the question I just raised there, and that is, if you know that somebody's going into your past background to expose whatever unseemly aspect of it might be there, would you be less likely then to go to court at all?
Well, the thing I have a problem with is where it concerns minors. And I was a minor, and I was a minor victim. I was 12 years old. I just don't see where anybody could consider I had a previous sexual, history.
Well, if you didn't, then you don't have a problem. So let me put it to you differently.
They confuse me when they say that, that the victim should be, that they're not a victim until the defendant is found guilty.
Right.
And yet, in my case, I was already harmed. You see what I mean?
I do indeed.
And when they say they're not a victim.
From your perspective, I think we all can share that sense of it. What the law is charged with is seeing to it that an individual is not prejudged. That is, that we don't assume this individual is guilty of the crime you're talking about. In your mind, you're certain he is. You see? That's the difficulty. What I want to know from you is, would you, as an adult today, be less likely to report the fact that you were raped if you thought that somebody was going to delve into everything you ever did in your life and maybe hold that up to public scrutiny?
No.
You wouldn't be less likely?
No.
All right. Did you feel, Sydney, at one time that people were a darn sight less likely?
Absolutely. We made it a policy to tell them from the beginning that, and it was the first question most victims asked, are you going to go into my background? I don't want my mother to know about my boyfriend. Exposing people's backgrounds really frightens them away. And I don't think defense attorneys go into it because they really think if you're promiscuous, you're more likely to consent. I think they do it to throw mud. I think they think if they can make the victim look bad, they got a better chance of getting their guy off because the jury won't care what happened to her that night. And I don't think anybody seriously believes that someone who slept with 99 people and didn't complain is more likely to have consented the one time that she complains that she was raped.
All right, so what you're doing is sullying up the reputation of the victim and saying, in effect, whatever she got, she might have even deserved, and even if she didn't, benefit of the doubt says, why pick on her, right? Or why pick on my defendant? You are a counselor in these cases, am I correct?
Right, and I'm also an emergency room staff nurse.
All right, what do you see from your perspective? Now, you talk then to people who have recently been raped, and they come to you, and they pour their heart out to you, obviously, about what has happened to them. Do you agree that if their entire life is going to be held up to scrutiny during the course of that trial, that they might just say, forget it, I don't want to go to court on this one?
For me, too, this is the first question they asked me. First of all, we have problems dealing with the fact that they're going to report it to the police, let alone whether they're going to go through the judicial system. So therefore, we have to start from the very beginning. My question is, why is it that we only seem to talk about women who the defense counsels can question their behavior in their backgrounds where it's questionable. We never question other rape cases that go on day after day where there probably isn't a question of Tommy Smith, 3-year-old, or 40-year-old woman who happens to be the wife of a doctor or a lawyer.
All right, would it be relevant? Let's turn it around then. Would it be relevant if we said we have here today Mary Jones, and Mary Jones, we will show you over the next 5 days, has never done anything wrong in her life? I mean, would that be relevant? Is that what you're suggesting? That why don't we hear about all of these people about whom there was nothing in their background that was unsavory anyway?
Well, based on what people want to be done, which is the names published in the paper and over the media, that's what's going to happen. We're going to have the names of all the women who were raped in the malls. We're going to have all the children who are raped every day, 5, 10 a day.
All right. Why is that an item of dishonor? Let me throw that to Ron Pena if I can. I have never been able to understand why somebody who is attacked and raped is somehow or another held up to public shame because of the attack. I don't understand that, and yet that has to be the underpinning of saying, don't put my name in the paper. I don't want people to know I was raped. Not so with armed robbery, not so with breaking into my apartment, etc. What's the genesis of all this? Why are we afraid to show the identity of an individual who's been raped?
I think basically it goes back to the way we've been raised. You know, it's been a man's world, frankly, and the rules have been set in the law by men, and there's something that you look at, and it's the shame is on the woman. It's her fault. Why? How long have you got, David? The fact is, if we go back in history and how we've
Can we assume that it's basically unfair?
Absolutely it's unfair. No one's discussed about how we go back into looking into the defendants' backgrounds as to how promiscuous they are.
All right, they do, though. Let's talk about what you do. Let's talk about what you do with defendants' backgrounds.
There isn't any good prosecutor that doesn't throw mud. And if they may not throw it directly, they'll throw it indirectly. And they go through back doors, side doors, any door they can possibly get their hands on to get convictions and send people away to Walpole, which is a horrible, dirty, filthy place. And if society wants to put people away in these kinds of places, and it's acceptable in society, then there has to be some mudslinging. And I think that this mudslinging is part of our system. There is mudslinging. It's unpleasant, it's unfortunate, but there are two issues that are at stake. One is freedom, and the other is guilt. And if you're going to find someone guilty of a serious, serious crime, such as rape, then they need zealous defenders like Pat Piscitelli and other people. And we have to bring out everything, just like the prosecutors do. And if a defendant takes a stand and there's a prior conviction on this defendant when he was 8 years before for something that really isn't relevant to this crime, the prosecutors will bring out those convictions and use it to discredit the credibility of that defendant.
Let me get, if I can, a brief response from Ron. We're going to take a break after that, and we'll be back to continue the discussion.
You know there are statutes that don't allow us to bring in anything in the past of someone. It's strictly controlled, and a judge looks at it.
But his example is right. An 8-year-old felony conviction would be admitted.
We found, yeah, but not his 8-year-old.
All right. On that note, and the beginning of the mudslinging episode that we engendered here, we're going to take a break. We will be back. We'll talk more about that rape trial, and we'll bring in, too, the press into the discussion. Come on back. Rape shield law. When we left, we were talking about mudslinging. Prosecutors, they say, are slinging mud. Defense counsels are slinging mud back and forth in order probably either to confuse or to raise some inference of sympathy, either for the defendant or for the individual who's there complaining of the crime of rape. The question I want to raise in resolution of that issue is, what about the individual who has been raped? She sits in the courtroom, and there's an attack mechanism going on between prosecutor and defendant. Do any of you feel that somehow or another that leaves you out of the process entirely? Does anyone have a judgment about that? You?
I feel that you have no voice in what's going on.
You as a victim, you mean?
Right.
Okay.
Actually, as a survivor. We
All right.
prefer to be called
Tell us why
survivor.
that is. Why do you prefer to be called a survivor than a victim?
Well, a victim makes you in a sense, connects you directly with the rapist still. Whereas if you're a survivor, you've regained control over your life to a degree. Also, I think surviving is an ongoing process. And surviving rape, even after a number of years, is an ongoing process.
All right. Now, you are a survivor, and you've been listening to the discussion that's gone on here. How do you feel when you hear people say, we're slinging mud back and forth to some degree here to try to win our side of the argument? How do you feel when you hear that?
I feel that the survivor who's in the court is sitting there and is just a target. She has no control over what happened, pretty much what happened when she was raped. She had no control over that, and now when she's in the court system and she has no control over what's happening to her in the court system.
All right, so trauma number 1 can be the active rape, trauma number 2 can be going through the trial.
Exactly.
What happens in that instance when the jury comes back in, assuming that they find the defendant guilty? Is there some sense of conquest that you feel? Do you feel vindicated in your judgment? How do you feel?
You feel that you have to continue your life, and you have pieces that you have to put back together again that you didn't ask to have spread all over this county.
All right. I want to ask you, before we go to some of the members of the press who are here, how would you have felt as a survivor, victim of this crime? How would you have felt if your name and face were displayed all over the television and the newspapers?
I think I would have been devastated.
You would have been?
Yes.
You feel then that society generally would think of you differently after the fact than they did before?
Well, look in this discussion that just started here this evening. I mean, a minute into the discussion, and already we were talking about promiscuous women in connection with rape victims.
Okay, let me go to some members of the press. Amelia, let me ask you if I can. You covered, obviously, the Big Dan's rape trial for us here at Channel 7. What is the policy that you follow in this coverage, and why do you think it's important to hold anonymous these people who are complaining that they've been raped?
Well, we followed the policy here at Channel 7 not to divulge the name of the victim at Big Dan's, and we, of course, were restricted from photographing her by the judge. And that was the policy here at Channel 7, and as the reporter who was covering it, I was instructed to follow that policy, and I followed it. And as a reporter, I can see, who's trying to remain objective about the whole thing, I can see the pro and con of divulging the name very clearly and very strongly.
What are they? Tell us what they are. Pro obviously is you're covering the news, you want to get all of it, right?
Well, not only that, but the argument, I think, is very valid that the defendants' names are dragged through the mud, and if they're found not guilty, their names are still divulged, have still been made public. You know, but on the other side of it, divulging the victim's name, I'm sorry, but I cannot, rape is not a crime like any other. It is just not. It's not like murder or robbery or anything else.
Isn't that because of the way we think about it?
You're absolutely right. It is.
Okay, so it's a bias in the first instance in the manner in which we think about rape.
I believe that it is, yes.
Jim Johnson, you're a director here, an assistant director of the news department, but an individual who then directs this policy that Amelia just outlined for us. Amalia, I'm sorry. What did I say, Amelia? Yeah, sorry about that, Amalia. The policy itself, why have we implemented that policy, and why do you think it's fair?
Well, essentially, it's an outgrowth of a policy that once somebody is formally charged with something, indicted, a name will be used. In this case, given the sensitivity, that person is not formally charged with any crime.
Right.
So again, if there have been instances where there have been reported acts of various, and until a person is formally charged, we would not report it anyhow. So if somebody was, for instance, arrested in a case this evening and not formally charged until tomorrow, if we had that name tonight, we would not use it.
But don't you agree that if, for example, society felt different about this crime, it wouldn't be a problem? I mean, it would be, if I'm mugged on the street, you'd put my name in. Dave Finnegan was mugged last night, the way home he had his wallet stolen or something like that. But if Mrs. Finnegan is raped, then it's an unidentified woman living in Boston was raped last night, according to informed sources or whatever. The question I'm asking is, why is it somehow or another defaming to the individual who's raped? She didn't do anything wrong. Why should it be that society should hold that individual up to some kind of disrepute by virtue of something she had no control over?
I can't answer why. It seems that it does, though.
So you agree that it does?
Yes.
All right. Mr. Gray, let me go to you just before I come in here, because you are running a radio station which published the name of the victim in the Big Dan's rape trial. Am I correct?
You're absolutely correct.
All right. Why did you think it was fair for you to do that? Why was that the right thing to do?
The victim's name was brought out in testimony in open court. There were perhaps 100 or 200 spectators there, all from the community. So her identity was known. Secondly, that broadcast was on live cable TV, nationwide and from gavel to gavel locally. For us to have bleeped out the name, which we probably could have done, we have the mechanism to do it, we have a 7-second delay.
Sure.
We probably could have done that. However, since the Providence Journal had already published her name, since it was on live cable TV, since it was well known in open court by people in the community, and it's a small community relatively, for us to have bleeped out the name would have been an empty, futile gesture.
Why, really? But you were talking to a different audience. A little bit of what you say sounds like this to me. Hey, Dave, somebody else already did it, and I'm justifying my conduct on the basis of the conduct of another. shouldn't you really be saying, I can justify my conduct on its own premise, all by myself. I didn't see anything wrong with publishing the victim's name, so I did.
All right, let me lay this on you. We are in the news gathering business and the news disseminating business. We are not moralizers. We're not clergy. We are not social psychologists. We are not rape counselors. We are in the business of getting the news and letting our public know what that news is.
This sounds like the editorial policy of the National Enquirer I'm listening to here. Really, isn't there a greater sense of... Isn't there a greater sense than that? Go right ahead.
It's a question of fairness. I think especially in the Big Dan's case, the question of the defendants' names being published day after day after day, not just their names, but their pictures in the worst possible poses, going into court in chains for a year. Now, to me, that's the more relevant issue coming out of the Big Dan's case.
All
And
right.
I think the
You're
fact
raising then the defendant's side of the story. You're saying you hold these people up to this kind of publicity, and the next thing you know, an inference is drawn that you got to be guilty or they wouldn't be dragging you in there in these chains every day. Is that right?
That were acquitted. I mean, they're devastated. Their families, those families are going to take forever to recuperate from that because of the publicity day in and day out. The fact that from day one, okay, they were found guilty through the media. They were found guilty through the press. They were identified as Portuguese immigrants over and over again. It was said they didn't speak English. They had cousins that didn't speak English. As a result, myself and the rest of the immigrant community came under an enormous attack. We were told daily on Mr. Gray's station that all of us should go back to Portugal, that we should all be deported. Okay,
all right. Let me go back. Let me go back just for a moment to the district attorney here, Ron Pena. What about it? This is the case in which both of you were very prominently involved, obviously. We're hearing now a different side of the story, and that is that not only is the press probably not fair to the victim survivor, nor is it fair to the defendant. How did you feel about it when day after day you're watching this take place on the television? Did you say, aha, this is going to be an easier case for me to win?
No. I think the issue becomes is jury selection, not what happens over the years. And I think this case had probably one of the fairest jury processes of selection than you'll ever find. About a month it took to select the jury. And that's who your audience is. And that's who decides guilt or innocence, not your people voting at home, whether they push a button yes or no, or whether they're listening.
What about the argument? What about the argument of names in the press? Let's go to that. And David, let me throw it to you. Names in the press, defendants and victims. Should we do it or keep them out?
I think there are 2 points. One that's already been made, that the word victim in and of itself connotes a decision that has already been made that this woman was raped. And until the jury speaks under our society, under our rules, that has not been determined. That's the purpose of us coming into court. I think there's a second problem, and it's not so much the press, it's televisions in the courtroom. And that is that the jurors, the actual people who are selected to hear the evidence, if the complaining witness is not allowed to be photographed, they're aware of that. And I think that they conclude from that, or may well conclude from that, that a decision has been made that this complaining witness should be protected, but even though we say defendants are presumed innocent, we don't have to protect them at all. I think it's a very dangerous precedent.
How much, though, do people believe? How much do people believe, you're a defense counsel, how much do people believe the defendant's innocent anyway? I mean, it's a term of art, and the judge says
I agree with that, David, and the very problem is if they
that?
don't believe it, we better protect it.
All right. Do you think that the name should be published?
No, I don't. I think that we have to recognize that there's a presumption of innocence. A good example is the Willie Sanders case. Now, here's a situation where you had a man,
Tell us
he had
briefly
a family,
now.
he was a painter, 3 kids, a
Right.
wife, worked hard, no history of being involved in the criminal justice system, and he was charged, arrested, tried for rape. He was acquitted. One of the problems with that is, how does Willie Sanders deal with the problem? His picture has been on television, he's talked to the press, his family was ashamed, he was embarrassed. He has the same problems that a survivor, and that's what he called it when I talked with him. He called himself a survivor, but he said these are problems that he's always going to have. He can't live it down. He's been labeled a rapist.
Why can't we, though, why can't we balance that? We say on the one hand, we got to have a criminal justice system, and not everybody who's brought there is going to be guilty, and not everybody who is guilty is going to be convicted, by the way. Why can't we recompense Willie Sanders and say, all right, Willie got a bad deal, let's try to do something about it through our legislature, and that's possible. Why can't we do that at the same time, allow the press to do what they're entitled to do under the First Amendment. Why can't we balance the interests?
You can balance them, because if the press is entitled to report the facts, there is no need, there's nothing gained by putting the name of a victim or a defendant in the paper. They can report the incident. A man is charged with this crime, and a woman is the victim, or any crime. An armed robbery, it could be anything. The same end is served. The public has the right to know what's going on, and they do know, but that way both parties are protected, the victim, survivor, and the defendant.
How much should we restrict, though, the press? How much should we restrict the press? Ken Darcy, go ahead.
The jurors in this particular case, their names were published, and district attorneys are already saying in final argument, you're the conscience of the community. You go back. And these people say, I got to go home. I got to go to my church, and all my neighbors know me, and this is pressure that the jurors face pro-Commonwealth because of the fact that they have been subjected to the press. Everyone in the neighborhood knows them. Everyone in the county knows them. And they have to go leave the trial for the rest of their lives.
They're an instant celebrity. Amelia, let me go back to you on that. Amalia, I'll get this right in about an hour. I can see that. Amalia, let me go back to you on that. What about it?
I agree with this gentleman, first of all, that there really was nothing to be gained by using the woman's name. And I know that we discussed it after...
What about names generally? I mean, is it reasonable for you in a report, a televised report, we're showing figures going through the dock, and we say, the following individuals were victims of armed robbery tonight. Unfortunately, we're not able to bring in their names because our policy from here on in is not to do it, or whatever. Does that sound reasonable to you?
Well, it's like you said, reiterate your statement about if there were enough details to bring the whole thing to court, then there's a right to bring the name about, or to use the name.
That's one logical thing. I think that there are instances where, again, a name is not relevant. Somebody might say, I was in this footage. I don't want you to use my name. There have been times, again, on a very selective basis.
How reasonable is it on your reporting in the news? Obviously, we want to have a fluid reporting in the news. That's what the First Amendment's all about. On the other hand, sure, there are things you don't have to publish. Half the stuff we read wasn't really worthy of any publication anyway. But the whole business of a freedom of speech and free press is you can say things that are irresponsible, and you can publish them in the press. People do it all the time, Lord knows. People make money doing it. How do we balance those interests? We want to protect the victim, survivor, as we've been educated to tonight. At the very same time, we don't want to inhibit people from doing what the Constitution says they ought to be able to do.
Well, I think one thing you don't do is set policy based on atypical cases like Big Dan's or Willie Saunders. Most of the rape victims that we work with, and I run a victim witness program in Middlesex County, are not, I think, the stereotypical 20-year-old impulsive young woman that most people think about when they think about rape. There are elderly women, there are people who do not want their grandmothers to know that they were raped. They're young teenagers, they're young kids. They're not all young, promiscuous people that are out in bars. And there are people that are involved in cases that are pending now that are saying to me day after day, is my case going to be like Big Dan's? Am I going to experience the same kind of cross-examination?
Good. All right. There is a legal maxim that says tough cases make bad law. Are we trying here to do something with the rape shield law, Judge Fine, based upon Big Dan's and the Holbrook Five and some other celebrated cases, and should we not be doing that? Should we be going more according to a standard that might be more reasonable?
Well, I know that I've had dozens of rape cases tried before me where the name of the victim has been mentioned over and over again during the course of the testimony. The case has been publicized, but never have I seen the name of a victim publicized in the news media. I think that that's a good form of self-restraint by the media, and I would like to see it continued. I would hope that I don't know what the outcome would be if a statute were passed prohibiting it. I think that there are very serious First Amendment rights.
In addition to being a judge, you're a woman. As a woman, do you think that it's a more enlightened view in the part of society not to publish the so-called victim's name and not to let the identity of that individual be known?
I think it's a more enlightened view. I think women are embarrassed by being a victim of a rape. I don't think it's particularly newsworthy what the identity of the woman is. I think in general, victims of crimes, and in a case the victim is only a complaining witness, that's correct. But we can't overlook the fact that rape exists. There are rape victims. The law should be enforced. People should be deterred from committing rape. The way to accomplish that is to have people fairly tried who are charged with the crime, and you must therefore have victims feel free to come forward and give their testimony.
Okay, thank you. I want to end this on one note from somebody who's a survivor here of the crime of rape. In all of what you've heard tonight, did you hear anything that gives you any heart, any encouragement that society is learning more about the crime of rape and becoming more humane in the manner in which they treat it? Yes?
No.
Briefly, if you would. No.
No.
Well, that's about as brief as you can get. You know what I'm saying?
Being both a rape survivor and a rape counselor, I know that for myself, knowing what happened in the Big Dan case and other cases, I would not feel safe in bringing up, if I was raped again, to go to court. I didn't feel safe in the first time to go for the prosecution. And I know as a counselor, women have called us and said, I'm really scared about this. I don't trust going to the police. And they're nervous also.
All right. Okay, on that note, we are just going to end this debate at this point in time. I'll work to any place, gentlemen. There we are. This is fine. Thank you. We are going to be back in just a couple of minutes, and we will have a debriefing discussion. Our friends, the editors of the New England News Exchange, will be with us. We will talk more about the rape shield law and all the changes taking place resulting from it right after this.
Dangerous criminals, or is it just a license for the state? Plymouth County is a leader in wiretap in the Commonwealth, having in recent years used more wiretaps than all the other counties combined. Betsy Zula spoke with 2 defense attorneys as well as 2 Plymouth County district attorneys about that issue.
The police have so many techniques available that this intrusion into the privacy of individuals, to me, I think it's appropriate that you've asked me about this in 1984, because it smacks of George Orwellian 1984, where Big Brother watches you. That's bothersome to me.
The public is protected by court intervention. Each district attorney has to go to a judge to get permission, and even then it's used in a very limited fashion.
To me, it just is one more indication that in the name of law enforcement, the authorities are infringing more and more on individual liberties. And
it's a very specialized tool, that it is the only way of getting above the low levels in drug distribution and other types of crime, and that it's used very, very sparingly.
Before 1968, Chapter 272, Section 99 of the Mass General Laws said that wiretapping is illegal, and I quote, except when authorized by written permission of the Attorney General of the Commonwealth or the District's Attorney. Then in 1968, Section 99 went from 1 paragraph to 15 pages listing conditions under which a wiretap may be used. These include a court order by a Superior Court Justice, specified crimes for which taps may be used, such as murder or extortion, and that it may only be used for organized crime, as defined by the statute.
The statute in Massachusetts requires that it be part of an investigation of an ongoing and continuing criminal conspiracy among highly organized individuals, which is a definition of organized crime. It's entirely inappropriate and not lawful in Massachusetts if it's used in connection with any other kind of investigation.
Most cases involve people that the district attorney's office try to allege are involved in some type of an organized effort to do something illegal, and then they try and fit that within the definition of organized crime that is set forth in the preamble of the statute, which was intended years and years ago to fit what perhaps you would consider to be organized crime, which really is certainly not rampant in Plymouth County, that's for sure.
How about the number of crimes that are called designated crimes for which a wiretap can be provided? Do you feel that that list of 23 or so crimes is too wide or too loose, or that it's not applied too strictly enough?
What they do is they have designated offenses, and the statute would set forth a number of offenses. Really, it's an alphabet soup from assault all the way to homicide. They try and cover all of the bases.
Crime being investigated has to be one of the designated offenses, and there are many, many other restrictions.
What kind of crimes? What are some of those designated crimes?
The overwhelming majority of cases where we use wiretapping involve drug investigations. It's really the only way that you can gather evidence on the higher-ups. We have also, in some cases, used wiretapping to investigate organized crime involvement in illegal gaming.
All of the experts discuss the possibility of abuse of the wiretapping privilege and its effect upon individual civil liberties.
Oh, I think it has in the past, and I think it will continue to be. And abuse in the sense that if a DA wants to get a wiretap, what he's got to do is make application for it, and if he waits until he gets a judge who is more receptive to his views, one who won't look at his affidavit with very, very strict thinking, why, he can get one very simply. And that's bothersome about the wiretap law.
There's a theoretical possibility that it might be abused. Anytime you have a capacity to use a particular tool, that tool might be misused. In Massachusetts, the safeguards that are built in are so complete that I really think there's virtually no danger of a misuse of the equipment.
Could the wiretapping activities of Plymouth County District Attorney's Office ever be considered violations of individual civil liberties?
Well, there's been absolutely no successful claim that that's the case. We have never undertaken to use wiretapping as a tool without having thereafter made arrests, brought people into court, and convicted them.
I think Chapter 272 is a well-written statute in the sense of its strict definition of when electronic surveillance is appropriate, and I also think that the Superior Court judges who have the authority to decide whether or not electronic surveillance should be used, they certainly exercise their best judgment and their best discretion. But I certainly feel that the concept of electronic surveillance, if abused, certainly carries a very, very real possibility of serious infringement of personal liberties.
Have you ever defended and won a case where the prosecution has used a wiretap?
Yes, because it wasn't done properly, and I was able to suppress the evidence that was obtained. And in short, it did the Commonwealth no good in that particular case because they didn't dot every I and didn't cross any T so as to protect individual privacy.
Do you see the potential where this privilege could be abused on the part of the state?
It has potential. I'd be dissembling if I denied it, potential for abuse, but it's always, I would suggest, a trade-off between individual rights of privacy in this case and order in the community.
Many people have never heard of the Spinal Cord Society, and that is one of their primary goals, to increase the public awareness of the important job.
4 MBTA fare counters arraigned in court today. All are charged with felony larceny, accused of stealing more than $1 million from the T counting room. Eyewitness newsman Bill Shields reports this was their first day in court following last month's police raid on the Charlestown collection facility.
Hear ye, hear ye, hear ye. Suffolk Superior Court was jammed this morning, but not with the usual curious spectators. Today, 34 people in the crowd were defendants, T employees, each charged with larceny over $100. It was last month when 150 law enforcement officers rushed the T's central money counting room in Charlestown. 34 employees were arrested, including 4 supervisors. That's almost half of the collection division's entire staff of 75. It had been an 8-month investigation, spearheaded by the Attorney General's office.
There was extensive electronic surveillance conducted during the 4 months of the investigation.
In court today, each of the defendants pleaded not guilty, but the Attorney General's office says it has the evidence, proof that at least $1.2 million was taken last year alone, and probably much more.
I've always found that no case is ever as good as the Commonwealth says it is, so until such time as they produce hard, convincing evidence that my client's involved in anything, I'm going on the assumption that they're not guilty and will be found to be so.
Joe Deneen has been with the T for 16 years, and like the rest of the accused employees, he steadfastly maintains his innocence.
Well, sure that you'll be vindicated when it's over. Guilty, yes.
The AG's office said they were, in effect, skimming off the top. You say your client's innocent of that?
Absolutely innocent.
And you say your client did not take any money?
Did not take any money. Absolutely not.
All 34 of the T employees were released on their own recognizance, but that doesn't mean they'll be going back to work anytime soon. Every one of them has been suspended indefinitely. Bill Shields, TV4 Eyewitness News.
Says he drank too much. He claims the bars that served him are responsible for an accident that crippled him for life. And we'll talk to jail inmates who...
And 3 friends played racquetball here at the Norwell Racquetball Club. Afterwards, according to Ploss's attorney, the men drank beer and Cape Codders in the club's lounge. Then Ploss and one of the men reportedly went on to the nearby 99 restaurant in Rockland for a few more drinks. Just after 1 a.m., Ploss headed for home in Brockton. Alone in his car, he drove less than a half a mile before veering across Hingham Street and crashing into a tree. Police rushed to the scene. Ploss was taken by ambulance to South Shore Hospital. At 2 o'clock in the morning, Ploss's wife, Pamela, received a call about the accident.
We live across the street from my father, so I woke him up and he came over and got me, and we went to the hospital. My sister came across the street and watched the kids. And it wasn't until an hour and a half after we were at the South Shore Hospital that we found out what was wrong with him.
What had happened was that James Ploss had broken his neck and severely damaged his spinal cord. At 3:30 that morning, Pamela Ploss was told that her husband was totally paralyzed from the neck down.
It was about the worst thing that you could probably hear. I mean, I figured that he probably had a broken leg, a broken arm, or something like that. And I heard the words, but I don't think it still has actually totally sunk in.
Since March 26, Ploss has been treated at University Hospital in Boston. His speech has been impaired, but he's able to communicate with Pamela, who visits every day. The couple has 2 children. Daughter Jennifer is 3. Son James Jr. was born 3 weeks before the accident. Ploss and his wife have filed a $17 million lawsuit against the Norwell Racquetball Club and the 99 restaurant, claiming that the bars were negligent in serving him drinks when he was obviously under the influence. Both establishments have denied the charge. Massachusetts bars have been sued before in drunk driving cases and been found liable for serving alcohol to someone who is obviously intoxicated. But most of those suits were filed by third parties, relatives of people who were injured or killed by the drunk driver. What's unusual about this case is the person that's suing the bar is the one who claims he was intoxicated. Attorney Pat Piscitelli is representing Ploss. He says it's a bar's responsibility to stop serving intoxicated patrons.
When a person goes into a place to drink, he pays for that. He also normally tips the bartender, and if a bartender or a person serving drinks sees that a person is visibly intoxicated, and that's the key, if he has reason to believe the person is intoxicated and can't fend for himself, can't protect himself, then he should shut him off, or he should make efforts to shepherd him home with a cab perhaps, or other efforts to protect him.
The primary responsibility with respect to the consumption of alcohol has to rest with the individual, and perhaps with the individual's companions and associates.
Boston attorney Philip Murray represents the 99 restaurant. Murray says it is often difficult for a bar to know if someone is drunk. A patron may have had a few drinks before arriving. He may be taking medication or drinking on an empty stomach, all factors that could affect the influence of alcoholic beverages.
Unless that person presents some outward manifestation of intoxication, engages in some behavior which is out of the ordinary, not simply for a man on the street, but out of the ordinary for persons in an establishment, there is no way whatsoever that the bar or the bartender can tell whether or not the person is intoxicated or what their condition is.
If the case goes to trial, Piscitelli will attempt to prove that James Ploss exhibited obvious signs of drunkenness. The bars will deny the claim. The jury will have to sort it out. Emotions would also be a factor if the case goes to trial. Ploss's tragic condition and its effect on his family are impossible to ignore. On the other hand, if Ploss had hit another car and killed innocent victims, he would have been the target of the kind of public anger that set off the nationwide crackdown on drunk driving. Whatever the outcome, Attorney Piscitelli believes the case will have an important impact.
I think it will have made its point, and perhaps will better all of society for the effects upon serving of drinks to people who are visibly intoxicated.
I guess there's no question that already it's had an impact in terms of the way bars are reacting.
Yeah, I know that there are some bars in the metropolitan Boston area that are training the bartenders to be on the lookout and really watch for people who have had too much to drink and cut them off. And some restaurants have gone as far as offering cab rides or limo rides home to people who have had too much to drink.
And I guess if the incentive of lawsuits isn't enough, the Attorney General is cracking down, too, on the so-called killer bars. So it's a tough time. I mean, they really do have to be alert, as does the homeowner.
Yeah, it really is. You can get yourself in a lot of trouble if you don't watch out on every front.
Absolutely. In a moment, a report.
Hello, student.
That story. Mike, I understand that it took 9 months to investigate all that theft.
That's right, Dion. When the money was found missing originally, since then, 4 different agencies have investigated, and there's been a cloud left hanging over a small police department.
There's been a lot of tension amongst myself and the police officers, amongst the people. No matter where we go, we get questioned, what are you doing on this? Are you hiding it, or what is happening on this?
It started on February 10th, when Avon police brought a drunken man into the station on protective custody. He was placed in a cell and held overnight. More than $600 found in his pocket was placed in a police bag. Next morning, when the man was released, half the money was gone. 42-year-old Officer Russell Valancourt is now named by a special prosecutor suspected of stealing that money. Polygraph tests were given to everyone in the 12-member Avon department. In the end, Valancourt's name came out.
I don't buy that at all. I've not been given results from the polygraph tests. He's cooperated fully. He has taken all the tests they wanted to, several tests. Other people have been given tests, and I've not been given any results as yet, though I've requested it. I've not been given any reports as yet, though I've requested that as well. So until I could put my hand in the side, I'm a doubting Thomas, and I doubt that this person's guilty of anything.
At first, police had conducted their own internal investigation, then turned it over to the DA. His concern was public confidence, so a special prosecutor was named.
The public, on an everyday basis, is aware that the prosecutor's office works with a department, and where there was no specific target of an investigation, that in terms of the integrity in the investigation, it was a better course to appoint an independent special prosecutor.
It's a small department, 12 men here. We're like a big family. I just hope that it's wrong.
Now, Avon selectmen will meet tonight. That will be a closed-door session. They'll decide on any further action that they have to take, pending the district court hearing that has yet to be held. Also, Valancourt is the treasurer of his local union, so they'll have to make a decision on whether he keeps that office also. Tom and Dion?
Okay, Mike Levitt, I know he'll keep us posted.
Beautiful weather out there today,
Yeah.
wasn't it?